Hello and welcome to this edition of Inside the Courtroom, the Senzo Meyiwa murder trial rep. I'm Linda Mnisi. It's a pleasure to have you with us this afternoon. It's officially December holidays and that means court is on recess. But we continue to use this opportunity to revisit some of the evidence that we heard this year. And of course, in this episode, we will be touching on the evidence of Muzi Sibiya. He opened his case after accused number 4, Mthokoziseni Maphisa, Mthokoziseni Maphisa's failed attempt to get a discharge. So you can join our conversation on our social media platforms. That's at Newzroom 405 on X. But of course, to help me with this evidence, I have with me my guest that I'll introduce shortly. But of course, we also have a poll question that we run weekly. You would have seen it shortly. On your screens, and that's where you'll be voting on the viewer question that we have for you. But of course, on your screen right now, you're seeing my panelists, and that is Mpumelelo Zigalala as well as Sibongiseni Kunene. They are the legal minds that will be joining us this afternoon. But of course, I also made mention that we have a poll question where you can cast your vote and have your say. This week, we're asking, what do you make of Sibiya's case so far? Those options on your screen. It's coming along very well. The state has an upper hand and it's too early to tell. So make sure that you make your voices heard by scanning the QR code on your screen right now and casting your vote. But of course, you can also engage with us on our social media platforms at Newzroom 405, but you can also tweet me at Linda_Mnisi. But before I go to my guest, I want to set the tone by looking at what was put to Constable Sizwe Zungu about the version of Muzi Sibiya. Let's take a look.
Accused number 1 will state that in 2013, until March 2013, he was staying at Foslora's hostel at Basotweni section. But when he lost employment in March 2013, he returned home and stayed home until he returned again to stay with his uncle in Tembisa in 2015.
Is that the question or is that the statement?
I want you to comment on that.
I wouldn't know where he was working when he lost his employment. We have never discussed that.
The basis of that proposition to you is essentially this, that since March 2013, he's never returned to Johannesburg or Gauteng until 2015.
I saw him in Fosloras. I was with him, drank beer with him, and I'm the one who dropped him.
Now, on the 13th of October, Sibia took the stand, detailing a sequence of events characterized by assault and torture, which he believes was linked to the murder of soccer star Senzo Meyiwa. He told the court he was initially detained in 2019, the first time that he was questioned about his alleged involvement in the killing. He would be arrested again for an unrelated matter at the end of May 2020, but allegedly deposed a confession statement that day, which he denies. Now, a couple of days later, the 5th of June 2020, he allegedly pointed out 2 locations related to the crime. It was only on the 26th of October 2020 that he was officially arrested in the murder of the soccer star and made his first court appearance the very next day. But at the heart of Sibiya's testimony is that he was never involved in the murder of Senzo Meyiwa. He got to speak about it under cross-examination by the lawyer of accused number 4. And I want to bring in my guests right now who joined me via video link, Mpumelelo Zigalala as well as Sibongiseni Kunene. Gentlemen, thank you so much for your time. I'll start with you, Sibongiseni, because you are also among some of the people that follow this case, regularly. The version that we previously heard from Sipho Ramusipile, who at the time was representing Muzi Sibiya, saying that essentially he would have never been in Gauteng in the year 2014. But under cross-examination, he gets to go into detail around where exactly he was that year.
Yes, I get you. Good evening or good afternoon, everyone, and your listeners, Mr. Nisi. The version that he put, Mr. Sibia, is that of he was never in Gauteng from 2013 until 2015 March, if I'm not mistaken.
Yeah.
Right, and which then somehow seems to be mutually destructive with the version that, not the version, in fact, the evidence that he testified to the effect when he took the stand. But, well, in terms of the one that he gave it about that he does not know Zoom, which he later on corrected before even he went to cross-examination. But as things stands, it's not clear as to whether he was in Gauteng or whether he was at home, because we remember when he testified, he mentioned that his bank cards were given to the lady Bingbali, I think is his girlfriend, and wherein some of the transactions which were happening around Gauteng and others were happening in KZN. So seems to be problematic when you want to compare it with other pieces of evidence that he testified to the effect, because when he was taken into task, there was a sequence of the transaction that took place at or near the Basutwini hostel, I think Phosphorus shopping center. Yeah, that could be the problem in terms of his version as to whether he could clearly clarify that on this specific day, was he at or near that particular area or not. But as things stands, it's not that clear as much as there are these transactions, and also there is also his evidence that he has to take into account. Until then, maybe if there's other collaborative evidence coming from his side, as things stand, only one witness that has come to testify. It does not speak much about the whereabouts of accused number one. So we will wait until maybe even that Mbali, because it's a crucial witness for Muzi Sibiya to come and confirm as to whether he was given these cards and is the one who was performing this transaction on those days.
Mpumelelo, let me come to you. I mean, when counsel engages with a client, they would obviously get a version. And here we're seeing a development of a version. Initially, he never set foot, but when confronted with further evidence, it could have been, you know, at times he was here, at times he was not. Talk to us about the implications of that.
Good afternoon to you and also to your viewers. Well, it would be very problematic. Remember that when that version is put to that witness, it's important that you put the correct version in a sequence that we are later going to repeat, even if you augment and you amplify it in some ways. But it must be tested against the witness of the state so that you're able to gauge the veracity and the weight that must be put on the evidence that is brought by the witness of the state. Now, if you fail to do that, either deliberately or it was a mistake, then makes it a bit harder for you to do so in examination in chief, and then you open yourself up to cross-examination to say, why didn't you tell us earlier? What was the reason of you not telling your legal practitioner? And usually the legal practitioner is always blamed to say, I told my lawyer, but he did not communicate, so you can't blame me. But despite all of that being said, you must always go back to this sequence. Whatever assertion that you are going to state must then you must provide collaborative evidence. So if you are saying you're in Durban, yes, I was in Durban, what else can I substantiate or prove that I'm really in Durban? Either there's going to be a person who was with me on that particular day, or other independent evidence, your cell phone records, your transactions as the state has taken here. If you are using the road, for example, let's use a toll gate or any other petrol station that you might have stopped at. All those pieces of evidence or collaborative evidence are crucial to proving what you are stating. And if you haven't stated those during your examination in chief, during cross-examination is going to come up, but most importantly, the question would be, why didn't you state that while the state witnesses were still presenting evidence, so that you can be able to test whether what they are saying is really true or not?
Yeah, but also another thing that, Mpumelelo, I wondered about during that testimony on the stand by Muzi Sibiya is why did it have to come, or the question have to come from the lawyer of accused number 4? Instead of your own lawyer. There you would have had an opportunity to canvass all the details and get to explain to the court that, at certain instances you would come to Joburg, and one would assume that under those circumstances, it would be under control and, your counsel would know exactly where they're taking you. Why did it have to come from the lawyer of accused number 4 instead of his own lawyer?
I think maybe it might have been the pressure of the whole trial. There are going to be things that you are going to end up missing as a legal practitioner, although it mustn't be those crucial ones as the one that has been stated now. But usually when you have co-accused, you'd find that the other legal practitioners that are there will sort of assist if they're able to see that there's something wrong or there's an element that has not been put through. Another thing which will amplify that assistance is that, remember, they're all 5 sitting there and they're bound together by a doctrine of common purpose. So it's not going to help accused number 5 or accused number 4 if accused number 1 and 2 are found guilty, because then they will then say, through your actions, you acted through in the same concerted effort, I'm going to punish you the same, even though you're not the trigger pullers, but I'm still going to mete out a punishment which is equivalent to the person that actually went into the house and pulled the trigger. So, which is why you would find various legal practitioners sort of assisting each other to say, colleague, you might have missed this point. I want to lament this point and make sure that I'm able to ask it through, especially if you can then be able to amplify and assist the court into why you're asking that question, or it has something to do with your client, or it will be able to exonerate your client.
Yeah, you will also remember that during the era of Thulani Mngomezulu, there was also the version of Longwetwala and linking Longwetwala to the murder. I want us to take a listen to what was put at the time and the questions, in fact, that Sibia had to field after that link or that alleged link was made. Take a look.
The position that was made by Mr. Mngomezulu was that Mr. Longwetwala shot himself in the ankle in the process of shooting at the deceased.
Listening.
Do you have any comment?
But anything about the shooting of Senzo or anyone, and I know nothing.
You know, Mpumelelo, as well as Yusbongiseni, in fact, I'll start with Yusbongiseni with this one. When this version came, one of the questions that I had as someone who is in court was, if you don't know or you were not in Vosloorus when Senzo Meyiwa was killed, how else would you know who killed him?
Okay, I think in terms of this version, we need to be fair to Sibia, right? Because his defense is that of, I was never at that place, a particular place of the incident, right? Now, Mngomezulu put a version and says, Longwetwala is the one who pulled the trigger and a witness is going to come and testify to that effect, right? So maybe the assumption will be that of during consultation between Mngomezulu and Muzi Sibiya, then maybe Mngomezulu might have informed Muzi Sibiya that, well, I have just discovered a witness who then witnessed this incident, and this is what is going to come and tell the court that the person who put the trigger on the day in question was Longwetwala, and that information cannot only, it can't be an information that comes from Muzi Sibiya, because Muzi Sibiya says he was never there. And if you remember very well, when Mr. Mngomezulu put the version, he never said that Muzi Sibiya will come and tell the court that the person who pulled the trigger, it was Longwetwala. So there is a witness, and the witness can be easily be inferred that maybe somebody who operated Longwe, the one that Mngomezulu spoke about, Mr. Mbatsane and stuff, I think that is the doctor. So who then Omodise amongst those two. So that information could be relayed to those witnesses, to those people, to those doctors, maybe, to put it that way. So then after this, that information can then be relayed to Muzi during consultation. So Muzi cannot have a knowledge because he has already said that he was never at or near that particular area during the incident. Could be the witness who then witnessed this incident, who then maybe get the information from maybe particularly Longwe or whatever it can be.
So is it then fair to expect that he would have answered in that regard to say there is a witness that would have or that might come and detail this version, but I do not know, you know, about that particular incident. I do not know how Longwe walks. I don't even know Longwe Twala.
Well, that one it seems to be difficult for the witness, but the assumption, as I have explained earlier, that is that of during consultation, because when you plan your case, you definitely going to talk about witnesses that are going to be called, and if then during the consultation you must also inform that I also have witness A, and then who was witness A, B, Z, and Y. So the question could be fair if he had that knowledge, but seemingly it looks like he does not have the knowledge of that incident or either even knowing long. So that version become controversial to his evidence.
Mpumelelo, is what then happens to it, because he says he does not know Longwe Twala or even how he walks?
Well, that's basically the end of it if you can't be able to substantiate that particular assertion. But what I'd assumed at the time was that, remember that in this case there are two dockets. It may have been that in the other docket, which is not being used here, there are witness statements that are able to prove what that particular version of saying it's Mr. Longwe that actually put the trigger. But you must then be able to state, as a legal practitioner, before I put that assumption, I want to talk with this individual first, because I cannot bring a witness into court that I haven't consulted with, that I don't know how they're going to respond to the series of questions in which I'm going to ask them. If I do that, I'm basically shooting blindfolded, and I don't even know where the target is. It's not something which is advisable at all. So it may have been, or my assumption was that maybe you've looked at the second docket, you have seen statements that are pro of what you are stating, you'll then be able to substantiate what you're stating at a later stage through the provision of witnesses. But what we've seen now, we haven't seen someone coming up and saying, well, I'm going to provide evidence, or maybe there's still an opportunity to do that when you come back. I'm going to provide evidence that says, this is the individual that actually shot. Let's look at the ballistic reports that are there. Let's look at other reports from independent experts which are going to suit me in what I'm saying. Otherwise, option number two, which is sometimes we do as legal practitioners, is to throw a wild card to say, here's the version that we want to put through you. What's your response to it? With the hope that the witness is going to crack, or maybe will contradict, or maybe even agree to what was stating. But that's a very dangerous move to state assumption that you don't have concrete evidence of. It does come back to bite you at a later stage.
Gentlemen, I want us to hang 10 while we take a quick ad break, and we will continue with this evidence and more when we return. Welcome back. You're still watching Inside the Courtroom, the Senzo Meyiwa murder trial with myself, Linda Mnisi. Now, since the trial within a trial, Muzi Sibiya has denied deposing a confession statement. Even during his testimony, he remained adamant that these were not done freely and voluntarily. I'm still joined by my guests, Mpumelelo Zigalala, as well as Sibongiseni Gunene, who, of course, are our legal minds helping us unpack, you know, everything that we've been hearing so far. And I want us to pick up, Mpumelelo, on this issue of Longwe Twala. I mean, when you think about Longwe Twala and how he has featured in this case, there are also issues of firearms, and there being a firearm that may have come with Longwe Twala. So if the Longwe Twala version is suffering at such an early stage of the defense's case, what would then happen when it comes to issues of ballistics?
I think that's where you're going to have a problem. So the thinking should have been, if I don't have any ballistic evidence which is going to assist me, let me not even go within that particular direction, because it doesn't assist me to make an assertion while providing independent evidence. So if I have ballistics and even just one thing which is going to link him to that firearm, then maybe you can hold on it. Remember again, During examination in chief, when Lungelo was providing his evidence during the state's side, there was nothing which proved to be something which could be concreted or you could leach on and then maybe at a later stage develop it when your client comes into the witness stand. So that would have been an indication back then to say, don't go during this part, because even though it may sound much more credible, it may sound a bit nicer and a bit of something that be able to assist your client, is not going to assist you at all, because there's lack of evidence that you can be able to support it at a later stage. So I think maybe even if it's something which is remotely possible, the evidence which is there to collaborate it is not there. Rather not use it, because it's not going to assist you in the bigger scheme of things.
And I want us to come back to the issue of the confessions, because Sibia maintains that he was assaulted. Mboto wrote everything down. He was uncuffed and asked to sign, and that's when Mboto saw the bruises. But he was also, asked about the contents, rather, of that particular confessions. And I want us to take a listen to the questions, or some of the questions that he had to field in relation to the confession statement.
Marcos told us that Kelly want money from Senzo, but he never told Mkhulu that. Mkhulu, in parenthesis, traditional healer, checked for us and said we are going to succeed to kill the said person, and he also gave us protection in brackets, protection in parenthesis, medicine, and belts to put on our arms or at our waist, and which was going to make us to succeed in killing him and to protect us from any danger. We paid Mkhulu 50 rand for checking our job.
I know nothing about all of this. Gininda and Boto would know about this.
All right, we'll also have a guest in studio joining me now, Mabelane, who also, follows this case regularly. You've just heard that bite around the confession statement. Muzi Sibiya is adamant, Mabelane, that he really did not depose that confession statement freely and voluntarily. It's one of the critical statements in this case, especially in the case against him, that the state says he voluntarily gave us self-incriminating evidence. From your vantage point and how you've been following these proceedings, what do you make of that?
Yeah, good afternoon to everyone. You see, when the police gets the confession, they have to investigate that particular confession so that they can get an independent evidence. So they have done exactly that. I mean, the lead investigator, Gininda, has investigated it. And what is interesting about that confession is there is an interesting witness, Ubabzwane from Palm Ridge, whom the investigating team are saying, we knew of this Inyanga through accused number one. He came to court, he gave his testimony that he met with Muzi Sibiya in Eratin, where Muzi disputes ever being at. So this state witness was never cross-examined. His testimony is not challenged. So he corroborates some of the events that led to the confession and some of the details that are mentioned into the confession. And his testimony is still not challenged. I mean, it remains exactly like that. So I guess it's a common cause in legal terms. They will say it's a common cause, it's not challenged, it's not disputed. So the witness has left. So if you then bring a different version later on, they are obviously going to argue that you are tailoring your evidence as you go. So I think that the confession is going to be key for the state, obviously, to convict Muzi Sibiya, because as we talk now, it is admitted before court as an evidence, and it will obviously be evaluated with the totality of evidence when Rata gives his judgment.
One of the things that was raised, particularly in relation to the witness that you speak about, is the fact that when he came to the stand, he could not identify Muzi Sibiya that is spoken about. You know, he could not say, this is the Muzi that came and asked for help from me.
Yes, Rata will have to obviously evaluate that, but I don't think it carries much of that weight, much of the weight, because what is important is he acknowledges some of the events that happened when they visited him, corroborate the testimonies of the EMPD officials who took Muzi Sibiya to Eratin together with Kininda and Mohola, the whole of the rest of the investigating team. So his testimony corroborates other testimonies of the state, and is seen as an independent testimony, because how would he have known all those activities if he was not there?
Sibongiseni, what do you make of that, the issue around, you know, Babzwane failing to identify Muzi Sibiya, although the allegation by the state is that this is the person that would have helped them prior and after the killing of Senzo Meyiwa?
Well, Babzwane, I think he was cross-examined as much, not by all the counsels, but I just wanted to clarify that, because the point, in fact, his evidence, seemingly the state wanted to show the court that, well, because we're dealing with circumstantial evidence, we want to put this dot, that this gentleman, Mr. Zwane, knows Muzi, and before even going to the trial, within a trial wherein there was the confession that has the information about Babzwane, right? There was, in fact, a problem about the dog identification from Babzwane, as much as we also saw his evidence that he mentioned that there was Sibia, whom then I consulted with twice, right? But that Sibia that he consulted with, then we don't know for whatsoever reason, he failed then to identify him in court. So, one thing that has to be taken into consideration is that you remember that the only duty the accused has is just to cast a doubt. It doesn't mean that Muzi Sibiya must come and testify and also speaks about event as to whether Babzwane was arrested or not. He does not know if then it never happens in his eyes. But then the issue here, I heard that how will Babzwane then know the events as to whether there was Eratin, wherever the police station was. So the only dichotomy that maybe could be problematic here is that of he mentions Sibia, and Sibia is accused number one. Then that could be possibly the inference that can be drawn, that might have been talking about you, because on the same day that we are talking about, Sergeant Mkhola come and testify and said is the day when we went to fetch Babzwane, and you were also there. He also mentioned, amongst others, the other gentleman who was working for the cold case unit, and who then happened to took Sibia and passed by when Kininda was interviewing Babzwane. Then that is when Mkhulu said to him, Sibia, Kwenzenja, and something like that. So that evidence, well, it's not that much well challenged insofar as the other witnesses. But for Babzwane, it was only for a dog identification, not all the events that you need to speak about, because you don't have knowledge about his arrest. So what was supposed to be challenged by the defense, obvious, was whether do you know the Sibia that you talk about? And eventually that is what they did. And you remember, even the state decided just to release this witness as quick as possible, because by the look of things, it was solely brought before court for the dog identification, nothing else.
Mpumelelo, one of the things that the state, wanted to push, particularly with the contents of this confession statement, is that many of the details, or the details that come from it, wouldn't have come from Brigadier Bongani Gininda. These are details that only would be known by Muzi Sibiya. And right now we're talking about the issue of Babzwane, the traditional healer, and him saying Sibia. And Mthokoziseni telling us now that the inference that could be drawn is that this could be accused number one. Talk to us about that.
And maybe just to add on that, we must then go back and say this is a traditional healer, probably sees a number of individuals. When did you see him? Is it a person that comes and visits you frequently? So if that's not the case, well, I may not remember the face or other facial features, but I'll then would be able to remember that during around this time, there was a certain called person whose surname is Sibia that came in. Maybe that's what the state should have lamented on at the time and provided evidence. There's still an opportunity for that to do it when you're doing your closing arguments, trying to substantiate all the things that are there. But let's remember what the state is trying to do with their statement. They are saying, the statement has been accepted. We've won in that particular part. Now, what we are doing is showing the accuracy of the statements and the content of the statement as we move along. We are going to bring in a number of individuals that are independent, proving various elements of the statement that was submitted, and coming or drawing to the conclusion that you've just stated now. There's absolutely no way that so many individuals would be able, or one individual would be able to bring together all those things, be able to make a statement that is made to Mr. Geninda, and Mr. Geninda is the one that is going to pen it down and force you to sign it. So the only probability that is there is that you signed the statement, you gave the information voluntarily, and the information that you gave is absolutely accurate, because after going back and dotting the lines, we have been able to determine that what you've stated in the statement is actually true. So, which is why we are going to see the state pulling all these strings together to say, this is what we are going to weave in and provide a complete picture. What the defense has to do is to try and dismantle it, not only through dismantling by providing maybe mere submissions of saying I wasn't there or I'm not the one. Provide tangible information so that it makes it easier for the judge to find in your favor. It may be that as the defense, the only thing that you have to do is cast doubt, but make sure that the doubt that you are casting is strong enough in order to dispute any other inferences that can be drawn from the evidence which is brought in front of the judge.
So in this instance, when it comes to the confession statement, what would throw it out? Because we've heard the allegations of assault. They could not stand during the trial within the trial, although the judge did not give us his reasons, but he still said these confession statements were done freely and voluntarily. So in regards to the confession statement, what would help Sibia throw it out of the court?
It's the probability or the lack of probability of the submissions or the content of the statement. So if you say on this particular day I was in phosphorus, if I can provide evidence which is contrary to that, it says whatever that you've got in the statement is not true. Are there any other individuals that I can be able to call? Is there cell phone evidence that I can be able to bring through? Are there any other witnesses that I can be able to call through so that they're able to provide evidence which is contrary to what the statement is saying? On the days in which it is stated that I went to consult with Inyang, who can I call or what can I be able to produce which is going to discredit or be in direct contradiction to that? And then let's go back to the manner in which maybe I signed, the manner in which I would state certain things, and the period at that period of time, where was I? So that I'm able to discredit whatever the statement is saying. But with the one thing which is going to trump it completely, provide evidence and sequence of events which are contrary to what the statement is saying, then the court will be able to find in your favor. If you can't be able to do that, the inferences, the circumstantial evidence that is brought in by the state may end up leading to a concretized piece of evidence which will work against you, especially because the court has already pronounced on it to say, we are going to accept the statement despite the fact that there's a dispute around it. We're accepting it. The only thing that needs to be done by the parties is either to prove or to disprove what the statement actually says.
All right, so after the break, we get into the evidence of Muzi Sibiya's witnesses. You'd recall he brought 2 witnesses so far who've taken the stand, so stay tuned for that. Welcome back and thank you for choosing to stay with us. Let's turn our attention now to Sibiya's witnesses. And first up was Absalom Zungu, the father of Constable Sizwe Zungu, who seemingly distanced himself from the statement that the state alleges he made. And I'm still joined by my guest in studio. Mabelane Mabelane is a commentator, and you would know him from social media platforms. He's one of the people who believe that the state has the right people. But I'm also joined by legal minds via our video link. That's Mpumelelo Zikalala as well as Sibongiseni Kunene. I want us to talk about, gentlemen, the statement of Ubab Absalom Zungu. And again, this is a conversation that we keep having, and you had this conversation on your platform about whether or not there is a general consensus or an understanding, at least, about the role that this statement played. And if we go back to Gininda's testimony about how the statement came about and what the statement helped them to do.
Yeah. The statement came out during investigation. So I can obviously say that it's classified as an information within the docket. It's part of the information that triggered or that informed the police where to look. And the police followed that particular trail, and they unearthed an independent evidence that linked all of these accused to the death of Senzo Meyiwa. And on top of that, through that statement, accused number 1 and 2 were approached, and according to the investigation team, these were the people who entered the house. But the investigation revealed that no, in fact, there is more to this. So it's an information statement. It's more like me taking a phone call, calling the police, saying, hey, I've seen 1, 2, 3 happening at this particular house. It is exactly that. Yeah, there's nothing out of it.
Yeah, Sibongiseni, what do you make of that particular statement?
Yeah, I think it's you. As much as you don't want to equate it to an informer, but then it's just an information wherein the police maybe they found out that A, B, Z, and Y said to be involved in a particular crime, then which it does not amount to somebody that you can bring before court to come and confirm such information, because you look at the witness. The witness is just talking about double, if not triple hearsay, whatever it is, that he had people talking about A, B, Z, and he was not even at or near that particular area. He's not an eyewitness. He's somebody that had an information. But then you follow up that information. The unfortunate thing is that when that statement was followed up by the investigation office, and there is a fact that later on is discovered. So you can't then shy away from that evidence. Well, the statement does not hold any weight for it to be brought before court in proving or maybe disproving some of the facts in terms of the evidence that is before court, because it's only speaking about that I had so-and-so say somebody, or so-and-so also had somebody that is involved in a particular crime. So then you are following a lead. In fact, it's just a lead. It does not take anyone anywhere, the statement of Absalom Zungu.
So, Mpumelelo, would you say it was a clever move from the defense point to bring somebody who made a statement that everybody seems to agree was hearsay?
Not necessarily so, unless if your intention is to muddy the waters and try and deflect the attention of the court to something else, or maybe you are laying a foundation of what is yet to come. But if you are trying to prove the innocence of your client, it's not going to assist you at all. Remember, all the evidence in which you are going to provide is evidence that is going to attack the elements of the crime. So whenever a person has been charged, those particular elements, whether there are 5 or 6, you must be able to disprove or attack them so that you're able to get a not guilty verdict at the end. So if you are going to provide evidence that does not attack any of those elements, well, maybe it's just a nice to hear type of evidence, but it doesn't assist you in any way possible to say this is the manner in which the procedures were flawed, thus through the procedures being flawed, then the court will not be able to find you guilty. But I think on this one, it's not going to assist the defense in any manner.
And you can't talk about Absalom Zungu without, looking at the thread of relationships. Right from the testimony of Muzi Sibiya, he details some of the relationships that he has with some of the accused, but also he does indicate that he knows Absalom Zungu. But of course, there's an issue around, Constable Sizwe Zungu, because he says, I do not know Constable Sizwe Zungu, or in fact, I met him in 2017 and later in 2019. But when we look at the issue around the relationships themselves, in the statement, there's mention of Mthokoziseni, and he does indicate that at some point when his son came, he had asked Mthokoziseni to go. So these are seemingly people that know each other.
And it comes back to the doctrine of common purpose. Remember, that's what the state is trying to drive to. And what the state did here, whether intentionally or unintentionally, they've been able to get a witness that is brought in by the defense that proves this doctrine of common purpose, that says these individuals know each other. Remember when the trial started and when the state was presenting its case, we've always been given an impression that they don't know each other. They have been brought here through this conspiracy, and they have nothing to do, or there's no communication between the five of them. However, here you find an individual or a witness that is brought in by the defense that says something which is totally different, that says there's an error of communication between these five accused. They know each other, they talk on a regular basis. Hence, if they wanted to plan something which is like this, each of them would have came up with different resources, different ideas, so that they can be able to execute this particular crime. It may not be clear at this stage as to what the motive was, but in terms of piecing these two individuals together, it makes it much more credible. When you are sitting as a judge, your assumption would be, what is the intention of these individuals? Did they just meet themselves on the street and then decide to do this crime? Or was there a premeditated or a plan that actually ensued so that at the end of the day, they're able to execute it? And the mere fact that they know each other, it leans more towards the side of saying there was a plan that was constructed by them. They knew exactly what they're doing. It's just that we haven't found out what their motive was or what the reward was going to be.
Gentlemen, hang 10. I want us to take a quick ad break, because when we come back, we'll pick up on this particular issue around the relationships and who knows who. So stay tuned. Welcome back. Let's continue our conversation about the witnesses of Muzi Sibiya. That's accused number one in the Senzo Meyiwa murder trial. And you've just joined us. I'm joined by Mabelane, who is a commentator who's in studio with me via our video link. I'm joined by Mpumelelo Zigalala as well as Sibongiseni Kunene. I want to come back to you, Mabelane. The issue around how the relationships developed, particularly when it comes to Absalom Zungu's son. At some point we heard that he does not know him in total. And it's one of the points that were discussed in court. What is your view about that?
Yeah, I think Zigalala was right to say initially they claim not to know each other and even claimed they don't know Absalom Zungu, Sizwe Zungu. So initially it was put that they don't know Zungu at all, in total. And then after the break, they came and amended that version to say, no, in fact, I know you. Accused number one knows you because he met you in Tembisa in the company of Kwabini. And that was the second version. When Muzi took the stand, he introduced the third version, which said, no, in fact, I saw you in 2017 in Naledi Mall in Fort Loras in the company of Makosonge. So these are the three versions, and he was asked, he was confronted with all the other versions to say, why did you say this? And he never took court into confidence in terms of why he said those particular versions. And Ntanzi as well claimed he doesn't know the gentleman, Sizwe Zungu. Later on, and Usizwe said unamanga because we are very related. Ugogo wakhe ugogo wami wakantanzi. So, and Absalom Zungu corroborated that to say, no, this one, I am his grandfather. So we'll hear when Ntanzi is confronted with those, what he's going to say. But giving multiple version is not good. We have witnessed it in Tembisa court where Muzi was convicted. He has given 3 versions and he never took court into confidence in terms of clarifying why he gave those versions. So we'll see what happens. But I don't think it looks good from credibility point of view.
The point about the son of Absalom Sibongiseni is something that even Ukwabeni speaks about, that they came in 2017, and again, he would have seen him in 2019. Does it help Muzi Sibiya in any way, given that it's something that emerges at a later stage and not initially when Absalom, in fact, Constable Sizwe Zungu said, we were together at the Fosleros hostel on the day that Senzo was killed?
Well, it doesn't help that much, as much as it's the beginning of his evidence in bringing witnesses to come and collaborate his version in trying to rebut the evidence of the state. Because seemingly he had knowledge that, well, I met this gentleman and eventually we went to Kwabini's place, but on a particular day, other than the one that he's alleging. So suppose that day, Mr. Ramsipil, I don't know if he was still, he was still represented by Ramsipil, was supposed to put a version that, well, the events that you are talking about is never happened in 2014. It happened in 2017. That is when Muzi Sibiya met you at a particular shopping center when you were driving with Makosonke, and eventually then you drove to Kwabini's place. And that is when the event happened, not the one that you are talking about in 2014. So that version was supposed to be put to the witness that then he can then answer to it. So then now it's like maybe it looks like, you can say it looks like somebody who's tailoring. Why? Because such an important event, you know that it took place. But even though the other accused were not there, but it was only yourself, Muzi, as Makosonke, Kwabini, and the constable. So you should have just put that version to the witness and said, yeah, you are lying. It never happened that myself and accused number 2, 3, 4, and 5 were at a particular era on this day. The only day you are talking about when I met you is the one in 2017, where you came with Makosonke as well. We then drove to Kwabini's place. I think he should have just put that version, but then now it becomes shaky because it looks like he's tailoring a version.
Let me stay with you, Sibongiseni, because, you know, between these two witnesses, Kwabini as well as Absalom Zungu, the issues that come out in relation to, if you remember, the issue around the threats, right? There was cell phone evidence that was brought to say, Constable Sizwe Zungu said he called you, informing you that a relative of yours with accused number 5 was threatening him, but he had also met you at a wedding. And the issue of the wedding comes up again during the testimony of Absalom Zungu, and he confirms there was indeed a wedding, and he confirms that his son was at the wedding. I think also accused number 1 is placed at the wedding, even by Kwabini himself, and I stand corrected with that. But the issue around the threats seems to be another problem for Muzi Sibiya.
Yeah, I get you there. This event about the issue of the wedding that took place, it's problematic for Muzi Sibiya as things stands, because not even one witness, 2 witnesses or 3, right? It's the constable, Zungu Senior, as well as much as he came the following day and tried just to spin around about the marriage, but it was not that clear. And now it's Kwabini who's also mentioned the issue of the wedding. So it has been corroborated that indeed there was a wedding that took place, and Muzi was there. So the conversation that the constable is speaking about could have happened, because that is the inference that you want to have as the court, that he might be telling the truth about this conversation based on 1, 2, 3, and 4. Right. The issue of the threats, well, I think if I remember very well, then Mr. Zungu, the constable, mentioned the issue of the threats when he was supposed to meet Shabane and the rest, and then eventually he has to meet Gwini and inform Gwini that, no, this is what is happening now. So you must also watch out. So it's not as clear as to whether even Gwini was also threatened by these guys, but then now, considering that he's in court and is testifying in their favor.
All right. Unfortunately, gentlemen, that's where we're going to have to leave it at, because we have indeed run out of time. Thank you so much for joining us. But of course, you'll recall that we were running a poll this afternoon as this conversation was going on. And of course, the options that we have for you on that poll was, what do you think? In fact, that's the question. What do you make of Muzi Sibiya's case so far? 25% of you say coming along well, 31% of you saying the state has an upper hand, and 44% of you saying too early to tell. So those are the results that are coming through from that particular poll question that we have been running throughout the program. But that's all we have for you this afternoon. Stay tuned to Newzroom Afrika, myself, Linda Mnisi, and the rest of the team. It's goodbye.